It is unconstitutional to not have a court reporter and have a historic record of the proceeding, but we did get our media request.
Perfect. This is Susan Bassi. We traveled up to Sonoma County after family court judge Shelley Averill granted our media request to photograph and record court proceedings. In California, it's illegal to record family court proceedings without a specific court order granted by a judge, so this opportunity was significant. The hearing was important because back in 2019, all California family court proceedings had court reporters. It didn't matter if the parties had lawyers or were representing themselves. Every case had a court reporter creating a transcript or written record of what was said and done in court. These transcripts are critical for filing appeals, verifying court orders, and holding judges and lawyers accountable for what they say in court. But now, in 2025, a statewide lawsuit claims that over 1 million hearings have taken place without court reporters or official records. Courts blame the issue on a lack of funding and a shortage of certified court reporters. But what we found in Sonoma County tells a different story. The real problem appears to be tied to court appointed divorce attorneys known as minors' counsel and also called GALs or guardian ad litems. These are lawyers judges assign to represent children during their parents' divorce and custody disputes. These lawyers get paid either by parents or, if parents can't afford it, by taxpayers. Our visit revealed that taxpayers in Santa Clara County have spent $6 million on minors' counsel, while families can't afford court reporters or even lawyers of their own.
Did you lose your kid while you were pro se? So are you on supervised visits?
Yes, I can have supervised visits, but they're $1,600 a month, and I can't afford them. So they essentially gave me a no contact order, and they're penalizing me now because I haven't been able to afford to see him.
Over the past 4 years, we've been investigating why there has been a slashing of court reporters from family court, but an increase in attorneys making a lot of attorney's fees. We've read thousands of court files, court orders, and conducted countless interviews following the money and the noise in family court and investigating how things have gotten this bad. At the root cause of the worst cases, where parents are losing custody of their children or forced to pay obscene amounts of money for support and supervised visits, are the attorneys the judges appoint to represent children, also known as minors' counsel or GALs. To be clear, the Constitution doesn't provide for these attorneys, and once they're appointed, they have immunity and get to bill parents and taxpayers, and rarely is anyone watching over those bills and the fees they get. So we went to the local bar association where these attorneys are usually members. Just as we look to the training of police officers to see what they're supposed to do and what they're not, we look to that for attorneys who are trained to be attorneys for children, known as minors' counsel. And this document got leaked to us from the Sonoma County Bar Association, where we noticed that pro pers or self represented litigants are allowed to participate in the same classes as the attorneys who are getting trained to be minors' counsel. And so we thought we'd go and see exactly how this training works and let you know what lawyers can and cannot do, but mostly how they get paid and how it can be that when 90% of people have to represent themselves in court because they can't afford an attorney, they end up paying an attorney for their children in their own divorce or parenting case.
These pro per classes, Mark.
There are pro per classes?
Yeah.
Hello.
Hey.
Yeah. Not a problem. Yeah, could definitely connect with him, and then you guys can converse on what to put together. Perfect. Okay. Okay.
Okay, yeah, and Judge Bertoli may have some things he wants to send us as well. Okay. All right, Tom, thank you. Okay, bye. I'm sorry about that.
No, that's all right. I was told about the pro per classes.
Oh, we're not holding them here. I'm wondering if they're in Suite 200. Are you looking for Suite 200?
I just understood it was from the Bar Association, so.
Oh, yeah, we don't have any, we're not doing any pro per classes here. Are you looking for, were they saying they were here today, or?
No, we're just inquiring about it
Oh.
since we're next door today at a hearing.
Okay, I don't know any information on that, so maybe it hasn't gotten to me yet.
Don't you have trainings that the public can have? I thought I took one a while
Yeah,
ago.
we do. We actually have,
Like online?
yeah, if we go to our website here. So we have live programs that you can register for, but we also have our on-demand library that you can go on our website. And basically where you would go for that is you go to our seminar and events tab, and then you'll see a drop-down menu. You go to on-demand MCLE, and
Okay.
then you can register for any of the programs that are on there. As far as the pro per classes, I don't know any information on that. I'm so sorry. This is a
But
long
but
document.
but any member of the public can take those classes.
Yeah, you can definitely take the classes, especially if you're interested in something in the legal field, or if you're part of the legal field, or anything like that. So
Okay.
you can
Okay.
definitely look on our website and see
Okay.
what we have,
Okay.
and see if it's of interest to you. So
I don't think Santa Clara even has a physical location for their bar association anymore. So
oh, I've been hearing a lot of bar associations are kind of struggling right now, and some are like minimally operating or not operating. Yeah. So
anyway, okay.
yeah.
All right. Well, thank you very much.
Well, I'm sorry I don't have more information on the pro per stuff.
That's okay. We
I think
appreciate
that's
it.
what I
Thank
remember,
you.
yeah.
Thank you.
Is Becky here today?
She, well, we have two, Becky Berry?
Yeah.
Oh, actually, no, she's not. She only rents the office to meet with clients.
Okay, I was
Yeah.
just gonna say hi.
Oh, she's my sister, actually, so.
Oh, tell her Mark Andrews said hello.
I will let her know.
All right,
I'm actually
thank
gonna
you.
see her Saturday, so.
Okay.
I will let her know.
All right. Tell her she needs to get me some process serving.
Okay, I will.
All right.
Our modern family courts don't work the way we see on television, in the movies, or even the way they did way back in the 1970s. Today, if you can't afford an attorney, you have to represent yourself, and you have to know the law as if you were an attorney. In our modern family courts, 90% of people have to represent themselves in a divorce, custody, or probate case. Yet from 2019 to 2025, we find that judges are appointing attorneys more than they are employing court reporters to make historical records. And they're appointing attorneys for children, and in one county alone, that cost taxpayers $6 million. But there weren't court reporters in those same proceedings. We found from this training that attorneys are trained that they can get fee waivers for the children they represent and then have a court reporter present, but they're not doing it, and they're not making transcripts of those proceedings. So buckle up, because we found $6 million in one county being spent on these attorneys and charged to taxpayers, and we have 57 more counties in California to go.
Efforts of considerable argument are avoided in that clause. Assuming the court adopts the tentative ruling, and it doesn't indicate what county you're going to send it to, do you?
Sir, I have no idea. I think we're talking about different things. So the court's tentative ruling on this motion, what's before this court, was not about, sounds like you're talking about a change of venue.